All right, as the 16 Days of Activism kicks off, a groundbreaking constitutional court challenge has been launched out of the Pretoria High Court. The Embrace project is concerned about what it calls the problematic definition of consent and rape in the Sexual Offences Act. To discuss, we're joined by Leanne Germanos. Sorry about that. Thank you for joining us, Ms. Germanos. Tell us, why are the definitions so problematic to you?
Hi, and thank you so much for having me on. So if I could, just jump right into the issue and the reason for this constitutional challenge is most of the South African public, and actually me, who isn't actually a layperson, don't know that the current definition of rape actually requires the proving of an almost insurmountable element. If I could just read the current definition of rape, as it stands, it requires that any person who unlawfully and intentionally commits an act of sexual penetration with a complainant without their consent is guilty of the offense of rape. What most people don't realize is that when coming to rape convictions or when proving rape, it's actually not sufficient to prove that there was an act of sexual penetration without the consent of the victim. The prosecution has to go a step further, and that's what I mean by this insurmountable barrier, and have to prove that in the accused person's subjective state of mind, they intended to rape the complainant. So it's not sufficient to prove that the complainant was objectively raped, that they, were sexually penetrated without their consent. The prosecution has to actually still prove that the accused person intended to rape them. So this is quite a regressive definition. Many countries have actually moved on from this and have applied an objective test. South African law still currently uses this subjective test. And it's also testament to the shockingly low conviction rates that we have for rape at the moment. I think the last statistic that I saw was sitting at 8.6%. And as we know, most rapes are not even reported to the police. And if they are, very few of them even see the inside of a courtroom. So for those that do, 8.6% is abysmal.
Yeah. So tell me when this distinction becomes important. Do you have an example? Because somebody could say, well, surely somebody who rapes another person has the intent to rape that person.
So this distinction is probably best explained by the very reason we brought this application to begin with. Last year in August, so Women's Month, the Embrace Project was approached by a follower who is a rape survivor. And she told me the story of her rape trial. She explained to me that in her case, the magistrate had found that the accused person was actually just not a credible witness. He was arrogant, that he had committed an act of sexual penetration, and that she, as the complainant, had not consented. But despite all of this, the prosecution could not prove that he subjectively intended to rape her. And this is despite the fact that he had her pinned up, he had her legs pinned up. So in her state, she was paralyzed with fear, which happens with most rape victims, if not all of them, and was unable to verbalize or to sort of fight back what was happening to her. And because of that, purely because of that, the prosecution could not prove that there was an intent on the accused to rape her because she didn't verbalize her non-consent. And that is where the huge injustices come in. The magistrate herself in that particular case, and it can actually be read in our application, it's an annexure. The magistrate says that this requirement, the subjective requirement of intent, is absolutely unconstitutional.
And this has always been such a tricky issue. At what point is consent granted or withdrawn? And like you say, sometimes it's not verbal. Does this involve a huge understanding of the context of the psychology, these fears that you talk about in the instance of sexual assault? And that would be something bigger for the judiciary to understand. It's not just about the letter letter of the law.
While I agree that the psychology behind rape and also rape victims needs to be much better understood by judicial officers, which would require quite a bit of sensitivity training, even if they had that understanding, as the law currently stands, it's still not enough. It would still prohibit them from granting convictions, just as in the case of this magistrate, who had a total understanding of the fact that this rape survivor had been raped, but legally she could not find that the accused had raped her because of this subjective intent element that she just couldn't get past and that the prosecution couldn't get past. And so what we're trying to move away from is, instead of putting the victim on trial, where the victim has to prove that they not only didn't consent to the sexual act, but actually in some form or another let the perpetrator know that they weren't consenting, whether it be verbal or in some sort of form of body language. We're trying to move away from putting the victim on trial, and we're trying to say to the legislature, to the government, it's the accused that's on trial. It should be on the accused to attain what is called, or what is termed, affirmative consent. So it should be on the accused to actually take steps to make sure that the person that they're having sexual intercourse with actually consents.
All right, so you've launched this challenge. Are you optimistic you will succeed? Do you expect it to go through to the Constitutional Court?
I'm supremely optimistic. And the reason I say this is I cannot imagine our government sort of having the gall, I guess, to oppose this application. The only thing that could possibly be challenged is maybe the remedy that we seek in terms of the reading in, the interim remedy. But I am very confident that this application will either be unopposed, or if it is opposed, we will still succeed in it. And we're hoping that it wouldn't be opposed, and that the government stands, hand in hand with us on this very issue, even though we did point this issue out to the president last year in October, when the Sexual Offences Act sat with him, because it was being amended. And we asked him to please not assent to the bill and just actually send the act back to Parliament. Unfortunately, he ignored us, which is why we're here. But I have full confidence that we will get the relief that we're seeking, and that this horrendous definition, which is genuinely a travesty of justice, will be rectified.
All right, we appreciate your explanation. The Embrace Project Director, Leanne Germanos.